James Egan Holmes. Case number 12CR 1522. The records reflect that Mr. Holmes is present with his attorneys, Ms. Brady, Mr. King, Ms. Nelson, Ms. Higgs, and Ms. Spengler. And the people are represented by Mr. Brockler, Mr. Orman, Mr. Edwards, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. We are outside the presence of the jury. Did you have enough time to go through the latest draft of the instructions?
Yes, Your Honor.
All right, did the defense have sufficient time, Ms. Nelson?
I'm about halfway through.
Halfway through, do you need a little more time?
We could do that, or we could talk about the tendered instructions that I tendered, and then while you guys talk about the PowerPoint, I can finish.
All right, maybe we should do that, the latter. Let's talk about the last two tendered instructions. Let me just point out a couple of things to you before we get to that. In the latest draft of the instructions, all the changes that I said I would make yesterday should be reflected. But there are a few additional ones. And the first instruction, I added in a few different places, or a case like this, consistent with the latest admonishment that I gave the jury. In the instruction that starts with, you must treat the defendant as a uniquely individual human being, I made an additional change because, go ahead. You must treat the defendant as a uniquely individual human being. I made an additional change in that second sentence, the last part of the second sentence, because the first part of the first sentence refers to both the defendant and the prosecution. I felt like the second part should likewise refer to both the defendant and the prosecution. Otherwise, I was concerned that a juror may incorrectly infer that it would be okay to consider any public opinion or community sentiment that was for or against the prosecution. So I made that change, so I wanted to point that to you. Two instructions later, the one that starts with, as to each count of murder in the first degree, the sentencing hearing will only continue to phase 3. That one, I made the change that Ms. Nelson requested, which I thought was a good change with respect to the second sentence. But Ms. Nelson's change to that second sentence really made the first two sentences almost identical and quite repetitive. And so what I did is I combined the two into one. I didn't think we need to repeat it. And so instead of having two sentences now, there's only one sentence. I think those are all the changes that I made that I did not say yesterday I was going to make. Those are only the new changes that I wanted to point out to counsel, but you should go through them. I may have made other changes that to me are not substantive and are only as to form, but the ones that I went through I thought were the more significant changes, or the only significant changes that I could remember that we did not talk about yesterday. So, Ms. Nelson.
And I just wanted to let the court know that we would like the court to give our tendered mitigation instructions after the general definition of mitigation, after the instruction that begins a mitigating factor is not a justification or excuse for the crime.
That's fine. I'll do
And
that.
perhaps if the court is amenable to making that change to making this change. It might clarify things on the second page where the court says, therefore, any list of mitigating factors mentioned in these instructions could read any list of mitigating factors mentioned in the instructions that follow. And then the same change in the next sentence. Would address the concern that the court had about this yesterday.
Okay, I will make those changes.
And there's just one other question I had about the first paragraph of that instruction. I think it should say weighs in favor of a life sentence instead of weigh. Mitigation refers to anything about a person or his offenses that weighs in favor, because it's anything that weighs.
Tell me where you're looking at again.
Last sentence of the first paragraph.
Of the same instruction?
Yes. On the first page of that instruction.
Yeah, that should be ways. Okay, thank you for catching that. All right, anything from the people? Mr. Edwards?
No, Your Honor, not on those instructions.
Okay, great, thanks. All right, Ms. Nelson, let's talk about your two tendered instructions then. You have a copy for me? Yes. And the people have copies?
Yes, we do.
Okay, great.
And just to let the court know, I did file this with the clerk's office this morning, and I provided a CD when we filed it, so the court has an electronic version as well.
Okay, thank you. All right, let's take these two instructions one at a time. Do the people have any objection to defense proposed jury instruction number 73A?
Yes, Your Honor, we do. As to the paragraph that's numbered 6, any other evidence introduced that bears on the question of mitigation. That factor actually says any other evidence introduced which in the court's opinion bears on the question of mitigation. So it's a court legal question. It's not a question for the jury. It's telling the court what to admit into evidence as mitigation in the statute. So it's the last statutory mitigating factor.
I agree that that's an evidentiary provision, but ultimately, isn't it true that the jury gets to look at any other evidence introduced that bears on the question of mitigation? They decide, right, what's mitigation and what's not. So any other evidence that they deem is mitigation, and that's what I've been instructing them throughout, that in fact I instruct them about that in these instructions, that there's a provision in the statute that says anything else that you think is mitigation can be mitigation.
Except that's not what the mitigator is. Statutory mitigator says, which in the court's opinion. And so it's a court issue. It's not the jury issue. And the defendant has their theory of mitigation instruction that contains over 60 separate issues of mitigation. And further, we object to this instruction and all instructions as indicated night before last and last night that having free-floating mitigation is arbitrary and makes the sentencing procedure unreliable.
Well, I don't understand your last comment, Mr. Edwards, because you withdrew your objection to the one paragraph that we talked about that relates to mitigation before, so now you seem to be backtracking. I don't get that last...
Judge...
Hold on, let me finish. I didn't interrupt you. Please don't interrupt me. When we're talking about the instructions, I've given you an opportunity to be heard on any objection that you may have. And I have addressed all of the objections that you have made. I have addressed all the arguments that you have made, all the remarks you have made, all the suggestions you have made. I don't remember any suggestion or any objection that relates to what you just referred to instructions that have, I think you said free-flowing mitigating circumstances as being arbitrary. I don't know what instruction you're talking about. What instruction, in the instructions that we have, do you believe contains an incorrect statement of the law that relates to mitigation?
Your Honor, we withdrew the objection to that particular instruction, not because we believe that the law doesn't support our position, but rather because any prejudice from that favors the defense and not the prosecution, especially based upon the fact that apparently that was voir dired on. So all I'm doing at this point is restating the objection that we had yesterday concerning that the mitigation has to be specified. And we don't expect a new ruling. We don't have new argument. I'm just preserving our objection.
Well, you're not preserving anything if you withdrew your objection yesterday. So this is news to me. This sounds to me like the prosecution is admitting that it made a mistake throughout the entire individual jury selection process. And now all of a sudden they realize what the law actually is, and now they're saying, but Judge, since we made a mistake and we didn't catch it and we didn't know the law back then, we're stuck with it, so we're willing to live with it. That's what that sounded to me like. Yesterday, you withdrew your objection, so I'm not sure why we're talking about that all over again. I mean, you either you make an objection or you don't, and if you don't, I don't really need to know why you don't. That's up to you. But let's not go back to instructions that you've told me you don't have an objection to, okay? Does that make sense?
It's fine, Judge.
Okay. All right. The defense's response with respect to this particular instruction that we're talking about, and specifically subsection 6.
We agree with the court, and the reason I included that in there was because the court had instructed the jury about it in the introductory instructions to phase 2.
Okay, we've all been telling the jury about this from the very beginning of the case. Everyone has. The prosecution has, the defense has, I have. And I think, frankly, it's consistent with the law. I don't get to decide what's a mitigating factor. The jury decides that. And I think the case was pretty clear that it's improper to limit the jury to a set of exclusive mitigating factors. That's the reason why you have this particular subsection in the statute, because you can't limit the jury and say, look, these are the 5 statutory aggravators or 10 statutory aggravators, and you can't consider anything further. Now, my understanding of the subsection in the statute that talks about any other mitigation that the court deems in its opinion to be mitigation relates to what evidence the court allows. It goes to whether the court admits certain things into evidence or not. It is an evidentiary type of provision, but it doesn't mean that I get to decide at this point, this is mitigation and this is not. It's up to the jury to decide what's mitigation and what's not. And to the extent that the people have withdrawn their objection to other instructions, then I have to be consistent with those other instructions. And the people can't preserve their argument with respect to this instruction, but waive it with respect to the other instructions. You can't have it both ways. I can't confuse the jury. So yesterday, the people told me they were okay with the other instructions, and they did not have an objection to them, to the extent that they talked about allowing the jury to make its own determinations related to what's mitigation and what's not. Well, today, they can't come in and say, hold on, we object to this particular provision because it allows the jury to decide what's mitigation and what's not. Those are not consistent. And if I added here, whatever is in the court's opinion, whatever the court deems in its opinion to be mitigation, that's only going to confuse the jury. What's the jury going to know about that? I've obviously admitted some things into evidence. That's all the jury knows about. All the jury needs to know is that, if we're going to be consistent, at least with the other instructions, is that it is up to them to decide what fact or circumstance, what facts or circumstances constitute mitigation. So, based on the people's position on the other instructions, this particular objection is rejected as inconsistent. Is there anything else that people have with respect to this particular instruction? Mr. Edwards?
Not this instruction, Judge.
All right. Let's talk about tendered instruction 73B.
Judge, I'm going to argue that one.
Okay, Mr. Orman?
Your Honor, regarding this instruction, and I know the court is familiar with Tennyson because we've all discussed it numerous times, the language from Tennyson, I think that we need to be consistent with, and this is from page 799, so it's 788 Pacific 2nd, page 799, is that the court's advisement through the instructions to the jury must be done in neutral terms to avoid any implication that the court regards the facts as established, or if established, that they necessarily must be viewed as by the jury as mitigation. So and also obviously that they need to be supported by the evidence in some fashion. The way that this instruction is drafted, Your Honor, would not comply with the dictates of Tennyson. First of all, I'm just going to go through a number of things. If we look at the introductory paragraph, the paragraph that starts with "in addition," it does not indicate that the court does not view these facts as established, or that if established, they must be viewed as mitigation. I think it needs to explicitly state that. Secondly, and if we look at it, Your Honor, it says, you must consider any mitigating factors listed in this instruction which you as individual jurors may decide exist. Well, the jury can find that some of these things exist, yet not view them as mitigation, and Tennyson makes that clear. So I think what I would request that the court do is include language essentially from Tennyson that says you should not take this instruction to believe, that the court regards any of the facts herein as established, or that if established, that they necessarily must be viewed by you as mitigation. So I would request that that language be part of this introductory paragraph.
So you're not objecting to the language that's in the introductory paragraph. You're asking that I add some cautionary language to it.
Well, I am both, Your Honor. I'm asking for the cautionary language, but if you look at the first sentence, it seems to imply that the jury, if they find that the facts exist, has to consider them as mitigation. But what Tennyson says is that that's not the case. They have to find that they exist and determine that they're mitigation. So I think that that needs to be clear, and it also needs to be clear that the court isn't saying these exist. The court isn't saying that the jury has to find that, or that they have to consider them to be mitigation.
What is your request with respect to any modifications to the language that's already in the first paragraph?
My request, Your Honor, would that it would read as follows. In addition to the mitigating factors listed in the previous instruction, you must consider any mitigating factors listed in this instruction which you as individual jurors decide may exist and constitute mitigation, comma, as reasons for a life sentence over a death sentence. And then I don't have any problem with the next sentence, but then I would request a sentence. You should not take this instruction to mean that the court regards the facts discussed below as established, or if established, that they necessarily must be viewed by you as mitigation.
All right, Ms. Nelson, what's the defense's position with respect to those two requests?
We object, Your Honor. I'll tell the court that I phrased that introductory paragraph exactly the way that I did, because that is exactly the way that the courts in the two most recent capital cases that were tried in Colorado, David Bueno and Sir Mario Owens, phrased those instructions, and the trial courts in those cases gave those instructions, including that initial paragraph as drafted. I think there's perhaps a very minor difference between my language and the language that was used in Owens. I think this initial introductory paragraph does comply with Tennyson, because it's not it's telling the jurors that you must consider any mitigating factors listed in this instruction, which you as individual jurors may decide to exist. The issue in Tennyson and what the Colorado Supreme Court took issue with in Tennyson's mitigation instruction, if I recall correctly, was that the court in that case had instructed the jury, you must consider as mitigating factors the following. And so that is the reason I drafted this language as I did. I think it makes it clear to the jurors that it's up to them to decide, and we object to the proposed changes that Mr. Orman just mentioned. If the court has any concern at all about, well, I'll rest on my record.
All right, well, what Mr. Orman just said is an accurate statement of the law. I mean, I'm not the one, just as I said before, I'm not the one who decides what mitigating factors exist. And I'm not the one who decides, even prior to that, whether any facts that may be mitigating facts have been established by the evidence. The jury does that. So,
I agree with that, Your Honor.
all right, so there's no disagreement on the law, and the question is it appropriate to provide, to make the changes to the change, and then to add the cautionary sentence at the end? I'm not sure that, in terms of the change, that we need the word may. The word may is in there right now, and Mr. Orman suggested that we change its placement after the word decide instead of before. But frankly, I don't know what it adds. I mean, what I'm telling the jury is that that they, as individual jurors, decide, exist as reasons for a life sentence over a death sentence. So I don't think we need the word may in there. So I'm going to make the change with the exception of the word may. In terms of the cautionary language at the end, I don't have a problem with it, and I think it makes sense to include it, because it is the truth and it is the law. The court is not telling the jury these are facts that are established, nor is the court saying to the jury, if you find that these are established by the evidence, these must necessarily be viewed by you as mitigation. Both of those determinations are completely up to the jury. So I think both of those, hold on, again, I don't interrupt you guys, so you can't interrupt me. You have to wait until I'm done. I'll give you a chance to speak. I've given you a chance to speak before. Now it's my turn. If you want to say something else after I'm done, I'll give you an opportunity to do that, but you can't interrupt the court. I think what I was saying before I was interrupted is that this is a cautionary sentence at the end of the instructions, that the instruction, at the end of the first paragraph of the instruction, that is consistent with the law. And I think it's necessary to avoid the jury being confused or misunderstanding the instruction. All right, Ms. Nelson?
I apologize for interrupting the court. I object to that last cautionary sentence in particular because I think it goes much too far and perhaps even suggests to the jury the court doesn't find anything listed in this instruction as mitigating, which of course the court is neutral in these proceedings, and I would suggest instead, if the court finds it necessary to include some sort of cautionary sentence at the end of the instruction, would be to use the language. It's really not about the court, it's about the jurors, and the important thing is to convey to the jurors that it is up to them. And so I would suggest taking the language directly from Tennyson and stating, it is for the jury to decide whether the facts that the defendant asserts in mitigation are true, and if so, whether they are to be regarded as mitigating factors, instead of the language that Mr. Orman proposed.
Hold on. I disagree that that language is better than the language Mr. Orman suggested, but I think it's an appropriate addition. So I will add it at the end with one exception. Instead of saying true, I'm going to say established to be consistent. So I will use the statement that Mr. Orman suggested. That sentence will be in there, and then after that it will say it is for the jury to decide whether the facts asserted by the defendant in mitigation are established, and if so, whether they are to be regarded as mitigating factors, okay?
I agree with that, Your Honor.
Okay, great. All right, let's move on then. That's the first paragraph of the about 7 or 8 pages that this instruction goes on for. So what's next, Mr. Orman?
Your Honor, I note, and I appreciate counsel wrote this, and that counsel refers to their client as Mr. Holmes, and they have done so throughout any proposed instructions that they have provided to the court. But the court has always referred to him in the instructions as the defendant, and in all of these paragraphs where the defendant is mentioned, he is called Mr. Holmes. So my request is that they say the defendant instead of Mr. Holmes throughout. And I can go through each paragraph, Your Honor, but I don't think you need me to do that.
There's no need. Ms. Nelson, do you want to be heard on that?
Different. This is our theory as to why Mr. Holmes should receive a life sentence. A big part of that is that he's an individual human being, and the jury is going to be instructed that they need to consider him as such. We think the heightened reliability required by the 8th Amendment and Article 2, Section 20 of the Colorado Constitution requires that he be referred to as Mr. Holmes in this instruction.
Your Honor, if I may, I don't have a problem with that necessarily, but then I would just request that there be another sentence in the introductory paragraph, the ultimate sentence, I guess, the last one, that would say something along the lines of, the defendant has drafted and provided the following mitigating factors for your consideration, so that it's clear that the defendant's attorneys are the ones that drafted this if they're going to use the language Mr. Holmes. I think that would cure any problems I see by calling him Mr. Holmes.
And I'm assuming you object to that, right, Ms. Nelson?
Yes, Your Honor.
I think to be consistent, I will leave it as the defendant. Okay? Next.
The next thing, Your Honor, is, and to go back to Tennyson, these facts argued by the defendant in this instruction need to be supported by the evidence. And there are some in here that I believe are not only not supported by the evidence or contrary to the evidence. So instead of going through the problems in order, Your Honor, if I can just take the ones that I see with that particular problem and then go back to other issues that I see?
That would be great.
Okay.
And for the record, I said 7 or 8 pages. This instruction is actually 9 pages. So go ahead, Mr. Orman.
Paragraph 38, Your Honor.
All right, hold on. Let me get there.
Yep.
All right, is that the first place where you have a concern?
That is, Your Honor.
All right, paragraph 38.
Paragraph 38 is not only not supported by the evidence, it's directly contrary to all the evidence that was presented on this topic. It reads, the defendant, Dr. Fenton could have hospitalized Mr. Holmes against his will on a 72-hour mental health hold, but decided not to do so. Actually, the evidence was she couldn't because the law wouldn't allow her to based on the information that she had. So this is misleading and is not supported by the facts. Now, if they wanted to say something along the lines of Colorado law allows for a 72-hour hold under some circumstances, but those circumstances did not exist, that would be fine, but I don't really think that's mitigation. But as this is written, it's improper.
Ms. Nelson.
Your Honor, this is a reasonable inference that the defense is arguing that the jury should draw from this evidence. I disagree with Mr. Orman's interpretation of the evidence as it came out and the testimony as it came out through Dr. Fenton and other doctors. We cross-examined Dr. Fenton about the 72-hour mental health hold statute in Colorado. Now, it was Dr. Fenton's opinion and belief that she couldn't, that was her opinion, was that she couldn't hospitalize Mr. Holmes unless he had articulated specific targets to her. And that was, in her opinion and assessment, the reason she chose not to hospitalize him. But Ms. Brady cross-examined her about the language of the statute, which doesn't include anything about a person needing to identify specific targets in order to justify hospitalization. I think the statute says something like the person has to be a danger to himself or others. And when Dr. Metzner testified, I think it was in response to a jury question during the sentencing phase of the hearing, he said, I think it was in response to a question that the jury had posed to him about whether it is common for people with schizophrenia or related disorders to become violent. And Dr. Metzner's response to that question was that there's a statute in Colorado that allows doctors to hospitalize people who are a danger to themselves or to others or who are gravely disabled. And it is our position and our theory that it's a reasonable inference from the evidence that Dr. Fenton, though she chose not to hospitalize Mr. Holmes because she believes she couldn't, that in fact is not the case, and that she could have had she chosen and decided to do so.
Your Honor, respectfully, if that was their theory, they could have presented expert testimony to that effect. They didn't, and I suspect the reason is there isn't a psychiatrist in the country that would have said that. The evidence in this case is that the Colorado law did not provide for a person in the defendant's position to be taken involuntarily into a mental health facility with the information that he was willing to provide his psychiatrists. So this is not supported by the evidence and is contrary to the evidence. And if Ms. Brady wants to argue this, she can. But counsel at the beginning of what she said, she actually called this argument. That's what this is, argument. And this instruction is not for the purpose of taking a closing argument back into the jury room with the jurors.
Ms. Nelson, I do have a concern about the way this is worded. I'll give you a chance to reword it, or if you want to make any suggestions, I'm open to them. But the way it reads, it makes it sound like even though she knew she had enough to hospitalize the defendant, Mr. Holmes, against his will in a 72-hour mental health hold, she just decided on her own not to do so, whereas what she actually said was that she just didn't think she had enough. So, and I see a difference between those two. So if you want to say, hey, Colorado law allowed her to do it, but she concluded she didn't have sufficient information to do so, that's different. And I think that would be more consistent with the state of the evidence. I don't remember anyone saying Dr. Fenton made a mistake and she had enough. She just didn't realize it. She had enough to put a 72-hour hold on him, nor did she admit to that, that I remember.
I can work on it and propose something, a modified version of the instruction.
Okay. It has to be consistent with the evidence. So now, if I'm misremembering or if I'm forgetting something, let me know. But I don't remember anyone saying Dr. Fenton had enough information under Colorado law to put a 72-hour hold on the defendant. She just missed it and didn't do it. She either made a mistake or she just chose not to do it. What I remember her testimony was that she was aware of Colorado law, but she just didn't have enough information. And I don't remember anyone saying anything different about that. So if you want to reword that and then present something else, I will consider it. Mr. Orman, what's next?
The next paragraph in this issue, Your Honor, is 46. And the problem I have with this paragraph is it talks about these jail writings, which have been called at various times galactic colonization writings for sort of a science fiction theme that is in there. And the words galactic colonization. It talks about he remained psychotic in the jail between July and November 2012. Then it says he wrote the galactic colonization writings during this time period. I do not believe there's been any evidence put before the court that he wrote those during this time period, because my memory was Mr. Gonglock testified that he collected them from the defendant, and I think he said in 2014 is when he collected them from the defendant, and I think his testimony was he doesn't know when the defendant wrote these. And I don't think the defendant ever told anyone like a psychiatrist that interviewed him when he wrote these. I just don't think there's evidence as to when that happened. So I don't think it's correct to say that he wrote them during this time period.
Ms. Nelson?
Your Honor, there's a lot of evidence that came in that Mr. Holmes wrote these writings during that time period. I believe Mr. Holmes told that to Dr. Reed, and that came in through the videos. I know that Mr. King also cross-examined Dr. Reed about that, And Mr. Gonglak also testified about receiving these writings from Mr. Holmes and about watching the jail videos, surveillance videos of Mr. Holmes during the month of August before the jail stopped videotaping him and observing him writing in his cell. And I believe that there was also testimony about that from some of the other experts, perhaps Dr. Gurr in particular and Dr. Metzner.
Well, Mr. Gonglak did not say that the defendant wrote these between the time period in the time period indicated in here between July and November of 2012. He said he collected them after that, and I can't remember if it was at the beginning of 2013 or later. I don't remember him saying 2014. I thought it was 2013, beginning of 2013, but I don't remember.
I think he said February 14, Your Honor, but this trial has been very long, and I'm just going from memory.
You may be right. My recollection was that at some point, he said at some point the sheriffs had stopped videotaping the defendant into jail, and I think what I remember him saying was that the sheriff's department found these writings and had, I think, seized them and somehow the defense found out about him, and then they went and they got him from the defendant after the sheriffs had returned him to the defendant. And I thought it was at the beginning of 2013, but I'm not sure. In terms of whether the defendant said anything about this to Dr. Reed, I could check that because we have the transcript. In terms of whether Dr. Reed said anything about it, that would be harder because we don't have the transcript of his testimony, but I could try to check my notes on that. Ms. Nelson?
So, Your Honor, and I'm happy to look as well, but we're all pretty sure, number one, that Mr. Gonglak testified about observing Mr. Holmes doing the writings in August on the jail videos, but Mr. King cross-examined Dr. Reed about watching those videos and seeing Mr. Holmes writing during that time period.
Well,
but I also think Mr. Holmes told him that he wrote the galactic colonization records before he was medicated. I'm pretty sure about that, but I will check.
If I may.
That last part I don't remember. About watching him writing on the videos, he may have seen him writing, but he can't say that he was writing this particular. I don't remember him saying that he saw him writing about the colonization specifically on the video.
I think that's correct, Your Honor.
And again, I think it's certainly a reasonable inference from the evidence that if Mr. Holmes says that he wrote these before he was medicated sometime between July and November, and he's seen on the videos writing, and the experts are testifying to that is in fact when these writings were made.
Your Honor.
I agree with that, but I don't know where this comes from that Mr. Holmes said that. That's the point. I don't know who he said that to. If he told someone that he wrote him before he was medicated, then I would agree with you, but I'm just not remembering. I'm going to have to do some checking on that, and I'll let you folks do some checking on that. So.
And if I may, Your Honor, I believe that they wanted to bring in the testimony that the defendant told that to the investigator, but we objected, and the court sustained that objection.
I did sustain that objection. I remember it.
Yeah,
Okay,
so,
what's next?
Your Honor, if I can just go up 2 paragraphs, I forgot one, and this, I'm not sure if this is sort of under my next argument as well, but if you look at paragraph 44, the 8th line down, there's this sentence, this behavior is called echolalia. And the problem I have with that is, I think that's sort of argument, and I don't think that these instructions are for the purpose of argument. But I don't remember any witness saying that that particular behavior is called echolalia. And if I'm mistaken, I'll stand corrected. I don't think they ever asked an expert when the defendant said this, is that echolalia? And I'm probably mispronouncing that term. So that's the problem I have with that. The defendant may say that's a reasonable inference because someone testified what echolalia is. That may or may not be the case. However, if so, then all this is argument, that sentence. So an argument I don't think is appropriate. I mean, counsel talked about reasonable inferences, and that's fine. Jurors can make reasonable inferences. Counsel can argue reasonable inferences, but it's not appropriate in this instruction.
I do remember the mention of echolalia And I thought it was in connection with the defendant being in the interrogation room right after his arrest. But I don't remember who said that or where that comes from. Ms. Nelson, do you know?
I remember Dr. Gurr testifying about that, Your Honor.
I don't know that for sure. I don't have a specific recollection, but I'll put a question mark and let you folks follow up on that and see if you can provide any particular evidence of it. What do you have next, Mr. Orman?
52, Your Honor.
Okay, 52.
It says Mr. Holmes values his medications. I don't remember anyone saying that.
Ms. Nelson?
He said that to Dr. Reed, Your Honor, and to Dr. Holland. He had discussions with both of those doctors about the fact that the medications make him feel better and take away his symptoms.
He says, I value my medication?
Words, but I mean, I don't think everything has to be a direct quote, but I mean, that's certainly the gist of what he said, is that he likes being on the medications and he feels that he needs them.
Then it's argument, Your Honor. I mean, if he didn't say it that way, this is just argument from counsel to phrase it that way.
Well, I think values his medication is a little odd anyway. I don't know what that means. I value my medications. I mean, if what you're trying to convey is that he said that, or to say Mr. Holmes acknowledges that he needs the medications and he continues to take them, then that's what you ought to say.
That's fine. We can say it that way.
Assuming that there is evidence of that. Do the people have an objection to that?
No, I think there is evidence of that.
Okay, so I'll change it without objection.
You're on this, should I go on to the next paragraph?
Hold on.
Okay.
So it'll say, Mr. Holmes acknowledges that he needs his medications and continues to take them regularly, as prescribed and without opposition or incident. Okay, let's go to the next one.
58, Your Honor.
And this is the last page. Okay, hold on.
Yeah.
I'm sorry, Your Honor, may I just inquire one more thing about that? And is the court going to leave that last sentence? Mr. Holmes has expressed that the medications he is taking help him manage his psychotic and depressive symptoms?
Yes.
Okay, thanks.
You bet. Okay, 58. Mr. Holmes offered to plead guilty to all charges in this case if the prosecution would agree not to seek the death penalty against him, but the prosecution rejected this offer.
Well,
Ms.
Your Honor,
Nelson,
do I need to argue that one?
Right, Ms. Nelson, do we really need to argue that one?
Well, it's in the record, so
In the record, in the
it's
trial?
in the pleadings that,
Can you rely on anything in the pleadings? Can they rely on anything in the pleadings? I mean, come on, we can't tell the jury that, you know that. All right, the request is granted as to that one. That one's out. What else, Mr. Orman?
Your Honor, and I sort of mentioned this in a couple of the paragraphs that I was discussing, that I think that some of the language contained in some of the instructions is argumentative, and I don't think that that is appropriate. And I'll go through what I've seen as argumentative language. Paragraph 11, Your Honor. The fourth line down, there's a sentence that starts with, to the contrary. I think phrasing something to the contrary is just argument and is nothing other than argument and needs to be removed or changed.
All right, give me a second or a minute.
Okay. You have as much time as you need, Your Honor.
I disagree. The way it is used there is just making a point. It's not arguing. It's saying that Castroville elementary school teachers described Mr. Holmes as a bright child who had high academic ability and was responsible and well-liked by the other students. He received awards regularly. Teachers and administrators never observed him being rude or mean to other students. To the contrary, Mr. Holmes served as an example to other children during this time in his life. Mr. Holmes' teachers cared about him and continue to care about him. Those three words to the contrary do not concern me there, so that request is denied. What else, Mr. Orman?
Paragraph 15, Your Honor, it starts with this language, unbeknownst to. And I think that starting a paragraph that way, unbeknownst to, is argumentative. I don't have any problem with the content of that paragraph, but I don't like that language, and I think it's argument.
Is it the word unbeknownst, or is it the placement of the word at the beginning of the sentence?
Well, I guess it's both, Your Honor. But I just,
What other word would you suggest to make the point that the defense is trying to make, that Mr. Holmes began having unwanted homicidal thoughts in middle school, unbeknownst to anyone else at that time?
well, I would say it should say something like he didn't tell anybody about this, or no one else knew about this. But I just think unbeknownst is an argument.
Ms. Nelson?
I don't really understand why that's an argumentative word. I don't know.
It doesn't bother me either. It doesn't strike me as an argument, so the request is denied. What's next?
Paragraph 26, Your Honor, the last sentence starts with, "This lack of motivation was another prodromal negative symptom." I think that's a reasonable inference based on the evidence, but I just find that to be argumentative, and I don't remember anyone specifically testifying to that. So I don't think that anything that's a reasonable inference is something that they can put in here as mitigation. They can argue that.
Ms. Nelson?
Well, there are several paragraphs in this instruction where we discuss some of the behaviors that Mr. Holmes began to develop, and traits and different things that experts have testified are prodromal symptoms of his illness. I mean, Dr. Metzner and Dr. Gurr and even Dr. Reed and Dr. Woodcock all testified about the prodromal phase of an illness like schizophrenia and what the types of symptoms that Mr. Holmes was exhibiting that fit along with that prodromal phase of the illness. And I think it's important to include there because that's why we're asserting its mitigation.
And lack of motivation is something that both sides have advanced for different reasons. I mean, I remember Mr. Brockler asking questions of multiple witnesses at CU about the defendant's lack of motivation. And I remember also evidence from the defense's side about lack of motivation.
Oh, I agree, Your Honor. I completely agree. And I'm not saying that there can't be mention of a lack of motivation. But what I'm saying is, I don't remember any expert being asked, was that lack of motivation a prodromal negative symptom of the illness? So there has been discussion of what prodromal symptoms are, what negative symptoms are. That's true. But I don't think anyone has tied them together. Because of the fact that all of those facts are in evidence, there can be an inference that a juror could make. The defendant can argue that is the case. But I don't think that argument is proper in this instruction.
Who testified about this? Now I understand the objection. I thought the objection, since we got through all of the paragraphs and we're going back through, I thought it was just to language being argumentative, so I didn't understand. This seems to me to fall in the category of the objections that people were making when we first went through all of the paragraphs. This doesn't seem like an objection to language being improper because it's argumentative. So who do you believe talked about lack of motivation being a prodromal negative symptom of emerging illness?
Dr. Gurr as well as Dr. Metzner. And it doesn't, I mean, otherwise the instruction just talks, that particular paragraph just discusses that he, moved back home and slept and watched television and played video games, which the jury is going to think, well, why is that mitigation? And the reason is because that's a prodromal symptom of his illness, as the experts testified to. So we need that in there to explain why we're asserting this.
I'm inclined to believe that Dr. Gurr did talk about it, but I'm not 100% sure. So I'll put a question mark by it. What else?
Your Honor, paragraph 29, In the second line, there's this date, October 2011, and then there's even began dating another graduate student. I think the word even is argumentative.
About that word.
Okay, I agree that that word should not be in there. What, hold on a second. I'll take the comma out after, the comma after 2011, and the word even out as well.
Thank you, Your Honor. The next issue I have is in paragraph 29, and I'm going on to the second page of where that paragraph is. There's a sentence that says, these behaviors were the signs of increasingly prominent negative symptoms as Mr. Holmes's mental illness progressed. And my assertion, Your Honor, is that is a reasonable inference jurors can make from the evidence, but I don't believe that that has been specifically testified about, and I think it's just argument. Additionally, in that paragraph, Your Honor, in the last sentence, similarly, it says most, if not all, of these individuals mistook the defendant's awkwardness as characteristics that were not uncommon for scientists. There's been no evidence, no one testified that these people mistook anything. So that's argument. And it's fine, that is a reasonable inference someone can make from the evidence. The defendant can argue that, but that's not what the purpose of this instruction is.
Ms. Nelson?
Your Honor, again, I think all of the experts testified about, for sure, Dr. Woodcock and Dr. Gurr and Dr. Metzner talked about this period of time when he was pursuing his graduate studies as a time when he really, his symptoms began to worsen and he began to avoid contact with other students even more, that his motivation and his academic endeavors began to suffer, and that these went unnoticed in part because other people around him at the time had limited contact with him and believed that he was just another shy and awkward scientist. So that, I think that was very well supported by the expert testimony in this case.
I agree with Ms. Nelson with respect to the first part of the paragraph. I agree with Mr. Orman with respect to the last sentence. And frankly, the last sentence you don't need because the point is made before that. The last sentence is unnecessary. So I'm going to delete the last sentence but leave the other sentence in there. I think that there has been expert testimony presented by the defense to support the assertion that's included in there, or the fact or circumstance included in there that says that these folks who are research assistants recall or describe Mr. Holmes as making great effort to avoid social interaction with them, and he would often leave class immediately to avoid sharing elevators with fellow students, and that such behaviors were the signs of increasingly prominent negative symptoms as Mr. Holmes' mental illness progressed. I think that there is expert testimony from that has been introduced that would support that, but I don't think the last sentence is necessary, and I think it. So I'm going to delete the last sentence, but not the other sentence.
May I make an alternative suggestion?
Yes.
Instead, perhaps we could amend that sentence to state these individuals perceived Mr. Holmes' awkwardness and shyness as characteristics that were not uncommon for scientists.
You're saying that already in the previous sentence. The signs were largely missed by people who knew him in the graduate program, most of whom had only met him recently and had limited interaction with him that revolved around school. What you're saying is people missed it. People didn't realize this was a mental illness. It's the same thing.
Well, I think it's a little bit different because that previous sentence doesn't talk about the fact that these people all said, oh, we're scientists and everybody is a little bit awkward, everyone's a little bit shy, and that's how they interpreted Mr. Holmes' behavior. So I think that's why that second sentence is different than the sentence before.
I don't have a problem with the sentence that you've suggested, so I will add it. So I will delete the sentence that's in there now, and it'll just say, these individuals perceived the defendant's awkwardness and shyness as characteristics that were not uncommon for scientists. Give me just a minute. Okay, Mr. Orman.
Your Honor, paragraph 35, the fourth line down, there's two sentences. The first one starts on the one hand, and then second sentence is, yet on the other hand. That is pure argument. These two sentences are nothing but argument, and they can't be fixed. They should just be deleted.
Your Honor, Mr. Holmes talked to Dr. Reed about this. Actually, he talked to, from my recollection, all of the experts about this. I remember Dr. Woodcock giving a lot of testimony about this ambivalence and explaining the ambivalence. Dr. Metzner certainly testified about this ambivalence, that people, when they're sick, want treatment, but then they don't. And this was something that came from Mr. Holmes from his interviews with Dr. Reed in particular, where he talked about why he went to get help, but then there was a part of him that didn't want to continue in treatment, and that part ended up overruling.
I agree with Ms. Nelson, so that request is denied. What else, Mr. Orman?
Well, if I may on that one, Your Honor. Okay.
I've ruled. Let's move on. What else?
Paragraph 36, I agree that you can interpret the notes of Dr. Fenton as saying that his mental health was in decline, but I think by putting it that way, that's argumentative, because I don't think the notes actually say that. So that descriptor is argument.
Where are you at?
I'm sorry, the first line of paragraph 36, over the course of these months, Dr. Fenton's notes reflect Mr. Holmes's mental health was in decline.
All right, Ms. Nelson, are you okay with me changing that to, over the course of these months, according to Dr. Fenton, Mr. Holmes's mental health was in decline?
According to Dr. Fenton?
Right.
I'm fine with that change.
Mr. Orman?
That's fine with me, Your Honor.
Okay. All right, what else, Mr. Orman?
Paragraph 39, Your Honor. And maybe I should have brought this one up earlier, but it talks about a violation of HIPAA. First of all, I don't see how that's relevant. It's hard for me to imagine that if a doctor violates HIPAA, that's somehow mitigation. I don't even think that that's true. I don't think anyone has really said that it was a violation of HIPAA. And then going on in the next sentence, it says, however, even though I think that language, even though, is argument and is not proper language in an instruction like this.
All right, Ms. Nelson?
With respect to the HIPAA violation, that's what Dr. Fenton testified about, and I think she told Ms. Brady that on cross-examination.
I think she said the opposite, Your Honor.
Hold on.
Okay.
I don't know why that's, even if it's true, even if that's the case, and I don't know that that's what the record reflects, I don't know why that belongs in here. So
Well,
I'm going to take that out.
May I?
So it'll say Dr. Fenton also called Mr. Holmes' mother Arlene, period, and then it'll go from there. In terms of the second line, Ms. Nelson, do you want to be heard about the even though?
Well, may I make an additional record on the HIPAA issue?
No, I've ruled on that. That's not mitigation. Move on to the second line. Please.
We could rephrase, I mean, I don't think it's argument, so I don't think it needs to be rephrased. If the court has a concern about it, we could perhaps change it to Dr. Fenton's primary concern was Mr. Holmes's potential dangerousness, period. However, comma, she never told Mrs. Holmes that her son was having homicidal thoughts.
I think that's better. Thank you.
That's fine with me, Your Honor.
Give me just a moment, please. All right, Mr. Orman, what else do you have?
And, Your Honor, I just noticed this, and it's just something that's incorrect, I think, in the last sentence, where it says the Holmeses later attempted to follow up. I think actually that's contrary to the evidence, and it was just Mrs. Holmes that did that.
I think Mrs. Holmes said that she tried to call. I don't know whether she was calling on her own behalf or on behalf of both of them, but she's the one who said she tried to call Dr. Fenton and couldn't get a hold of her, didn't get a call back.
Well, Mr. Holmes testified about doing some research about Asperger's syndrome, and so he was part of that effort to follow up. That's why we phrased it the way that we did.
I don't think it makes that much of a difference. I remember her talking about it. I don't know whether she meant that they were both trying to follow up or if she was just the only one trying to follow up. It seems like since they were both talking about this and dealing with this, they both knew what was going on, and even though she was the one making the calls, they were following up, so I'll leave it the way it is. Okay?
Your Honor, before we move on from that instruction, may I propose that if the court is removing in violation of HIPAA, would the court consider including language stating Dr. Fenton also called Mr. Holmes' mother Arlene without his permission?
That's true, Your Honor. I don't object to that.
That's fine. Okay. Mr. Orman, what else?
Hang on a second, Your Honor. Your Honor, paragraph 45, actually, I'm not going to make that argument.
All right, what's next?
Your Honor, if paragraph 48, the second page of that paragraph,
Yes.
if we go to the last line, it says, again, at the end of it, again exhibiting echolalia, which I think goes back to, I agree that there was testimony of that, but the again thing is, the again thing, I think, is improper because of the previous argument I made about the previous paragraph with that language.
Ms. Nelson?
I think the court overruled Mr. Orman on that previous objection.
I did, but I don't know that you need again. Again
really
seems to
care.
me to just be argument and unnecessary, so I'll take out again. All right, what else, Mr. Orman?
Your Honor, if I want to go back, if it's okay, to the first numbered paragraph. And,
We're going backwards now?
yeah, I missed this one, Your Honor, I'm sorry.
Well, the first time we go through it, you're telling me I specifically asked you, is the first part where you have an issue, number 40, whatever it was, and you said, yeah. So I was thinking, hold on, I was thinking, great, we're going to move through this, great. Now we're going through it again. I mean, I keep looking at the clock, I still need to rule on the slides, I'm just telling you, I need to get an idea. If there are any more, if we're going to keep going back through this, then let me know now, so I don't keep thinking we're almost done. Because what you keep doing is, we get to the end and then you go, okay, now let's start over again, and we go to the beginning, now we're starting again. So at which point do we just move forward?
I appreciate what Your Honor's saying, and I apologize.
Okay?
And it's just,
I mean, we dealt with the first paragraph, we had argument on it, now we are going to deal with it again.
oh, no, Your Honor, I'm sorry, the first numbered paragraph,
Okay, number one,
number one.
okay?
Yeah. So,
Are there others that we're going to go through now again?
well, and if one of my colleagues points something out I missed,
Well, then, what I'm going to do is take a break, let you talk to your colleagues, figure out which objections you have, so that when we go through it, we go through it. I don't want to have to do this where we're going back through it again. Once we go through a page, we go through a page and we're done. So if you want to take a break, I'm happy to take a break. It's going to give Mr. Brockler less time and Ms. Brady less time to work on their closing arguments. But that's up to you. If you need to take a break, I'm happy to take a break. Would you like to take a break?
can I have a second to discuss that
Yes.
with my colleagues, Your Honor? Thank you.
Your Honor, while Mr. Orman is doing that, I can refer the court to Dr. Reed's final transcript. Starting at page 469, he begins discussing the galactic colonization writings with Mr. Holmes. And Mr. Holmes indicates that he attributed an unusual amount of importance to those ideas before he was medicated. If you go on to the next page, he asks about the time frame of the writings. He specifically notes it was before going to Denver Health. So I think about 469 to 471. He also says, we're talking about some point before you went to Denver Health. Mr. Holmes says, right. He says, do you know roughly when you started, maybe a month after my arrest? All that discussion is in the transcript, and that was part of the video that was played for the
All right,
jury.
thank you for pointing that out to me. I appreciate that. Based on that record, the objection by the people to paragraph 46 is now denied. All right, Mr. Orman, do you want some time to chat? I don't mind if you chat. What I need is to have one voice per side, and part of the difficulty when you have so many lawyers on each side is that everybody has an opinion and everybody wants to tell you their opinion. You've got 6 lawyers on that side, so I can understand, but I need one voice. So if you want to get together and figure out all of the objections that everyone has from your team, I'll take a break, let you figure that out, and then we'll proceed.
We don't need to do that, Your Honor.
Okay, great. So
A-
tell me what you want me to look at.
Actually, I just have one more request for this instruction, and that'll be my last one,
Okay,
unless you point out something to me that I need to talk about. Our request is that, and this is just on a different thing than we've talked about before, is that the instructions say, at the top of it, have a title that says the defendant's theory of mitigation instruction. Because it'll make it more clear that this is the defendant's instruction.
We object to that because none of the other instructions have titles. If the court's going to give that a title, then we would ask that the court take out the language that Mr. Orman proposed that the court add.
Well, Your Honor, it's true none of the other instructions have a title, but this is kind of a unique instruction.
There's case law that says that the court should not unduly highlight that an instruction is a theory of defense instruction. I think that would apply similarly to a sentencing instruction.
And Your Honor,
Hold on,
Okay.
hold on. I don't like putting titles on instructions, but I think it is appropriate to inform the jury that this is the defendant's theory of mitigation. So what I will do is include it in that first paragraph of the instruction. You know, when I gave the jury the final instructions at the end of the trial, one of the questions that they submitted during deliberations had to do with the theory of defense instruction. And they were wondering if that instruction was informative or why they had it included in the instructions. I think it can be very confusing when the court gives the jury instructions of law to have the jury believe that this is all coming from the court. Well, this one's not all coming from the court. Some of it is coming from the court. The part that I'm saying, hey, you have to consider these things. But this is not the court speaking to them. For example, there are things in here that says, for example, it says, number one, I'll just start with the first line. All of the experts who have evaluated Mr. Holmes in this case agree that regardless of a specific diagnosis, Mr. Holmes suffers from a chronic and serious mental illness and a schizophrenia spectrum of disorders. And it's almost like the court telling the jury, this is the evidence, you got to take it. This is how it is. It's not quite like that. And I think we have to be careful with respect to what I tell the jury. There are things in here that we've talked about that are clearly inferences that the defense is drawing, that the people dispute. So I think it's the jury has to know this is what the defense is presenting to them, and they have to consider it. There's no question. And then they have to determine, has it been established? And if so, is it mitigation? So my job is to make sure that they understand that what mitigation is, the definition of it, that they understand that they have to consider all of these facts and circumstances, and that they have to determine whether any of them or all of them or some of them have been established, and if so, whether they constitute mitigation. Ms. Nelson.
If, in that case, if the court is going to add that title, we would ask that the court, I think that's more than sufficient, that in addition to the language that I propose that comes from Tennyson informing jurors that they need to, that it's their task to decide, what facts exist and whether or not they're mitigating, is more than enough to convey to jurors that this is up to them. And I would ask that the court take out, in that event, the sentence, the cautionary sentence that, just because I'm reading this instruction to you, don't think that I'm finding any of this as mitigating, that Mr. Orman proposed earlier, because I think really then that's going way farther than is necessary. I think that the language in Tennyson says that the instruction should be cast in neutral terms to avoid any implication that the court regards the facts as established, or that if established they necessarily must be viewed by the jury as mitigating. It certainly doesn't say that the court should tell the jury that that the court doesn't necessarily find these facts as established. So we would ask that the court remove that sentence.
Mr. Orman, your response to that request?
I think that sentence is necessary to comply with Tennyson, Your Honor.
I agree. Okay, what else, Mr. Orman?
Your Honor, I know you generally don't believe lawyers when they say they only have one more thing, but in this case, that was true.
All right, thank you. I appreciate that. Is there anything else from the defense with respect to these two instructions, Ms. Nelson? I have a couple of question marks still left, or at least, let's see, I have paragraph 26. I have a question mark on.
And we may need a break to...
In paragraph 44, I have a question mark on.
And then I think I told the court that I would make an effort to redraft the I think was it number 38? Yes. And if we take a short break, I will make an effort to do that. And then if I may have a moment to confer with my colleagues on...
Yes, 38, you said that you would want a chance to try to redraft.
Yes. And so I'm sorry, it was 26 and 40...
44.
The echolalia.
Echolalia is 44. 26 is...
On 26, Your Honor?
Lack of motivation.
Yes, on 26, which was the lack of motivation.
Yeah.
This is a transcript. This is the transcript from Dr. Metzner's cross-examination. Mr. King asked him, this is on page 131, I don't know which transcript this is. I think he only testified one day. He testified 2 days? You've also heard, this is Mr. King speaking, you've also heard about a lack of motivation. From some of these folks, just thought he didn't appear to be that into it, didn't seem to be trying that hard. That would be consistent with the negative symptom of schizophrenia too. Is that right? And he says correct.
All right. Mr. Orman?
Well, that's all well and good, Your Honor, but that's not what this sentence says. So if it was rephrased to say this lack of motivation was consistent with, I wouldn't object.
Consistent with prodromal negative symptoms of
Or-
Mr. Holmes' emerging illness?
Or even just consistent with another prodromal negative symptom, or it's consistent with being, or something like that. But if the testimony was consistent with, then the factual assertion in this should be consistent with.
That Dr. Gurr also testified that this was a result of the illness, but we don't have, that this was a symptom, excuse me, it was a symptom of the illness. We don't have Dr. Gurr's actual transcript, but I took pretty good notes.
Can you check your
I
notes?
can.
Please?
Mhm.
Okay, great. Why don't you check on that with respect to paragraph 26, and then check on paragraph 44. And then if you want to try to redraft paragraph 38, that would be great. All right, anything else at this time? No? All right, I'm going to step down. I'm going to make these changes so that I can get the instructions almost finalized, and I'll come back and we'll deal with the 3 things that we have outstanding with respect to these 2 instructions. I got to get them finalized so that my staff can start copying and all that before I take up the PowerPoint presentation. So I'm going to step down and do that, okay? Anything else from the people at this time, Mr. Orman?
How long does Your Honor anticipate this break taking?
At least probably 15 or 20 minutes, so, okay. All right, anything from the defense, Ms. Nelson?
No, Your Honor.
All right.
Make an effort to read the
Okay, great. Yeah, we'll be on break for at least 20 minutes. The court will be in recess. Thank you.